English legal shorthand 100 words per minute. Ready? Start. The petitioner issued the provincial assessment on 8th January 2010. Stop. Respondent number 1 was given hearing on 22nd March 2010. Stop. He was asked to produce documents showing industrial activity or any sanction for commercial use. He was asked to show disclosure of tenancy as required under Regulation 10 and 11. Stop. He produced no document. Para. The petitioner thereafter passed the final assessment on 26 March 2010 under section 126 bracket 3. Stop. The assessment was limited to 12 months as required by section 126 bracket 5. Stop. The assessment was issued to respondent number 1 alone. Stop. Respondent number 2 had no right to participate or challenge the proceedings. Para. According to the petitioner, respondent number 2, though having no locus, filed an appeal under section 127. Stop. He claimed to be an authorized consumer. Stop. He never applied for change of name. Stop. He never secured any permission. Stop. He relied on no disclosure. Stop. An unauthorized user tried to avoid liability by presenting himself as an authorized consumer. Para. The appellate authority accepted this claim. Stop. It held that respondent number 2 could be treated as an authorized consumer. Stop. It treated the matter as a dispute of tariff clarification. Stop. It set aside the statutory assessment. Stop. It directed MSEDCL to issue supplementary bill without invoking section 126. Stop. It expected MSEDCL to give wide publicity of tariff changes. Stop. It relied on an decision which had no jurisdictional relevance. Stop. It nullified the statutory consequences of unauthorized use. Para. According to the petitioner, these findings ignore the inspection record. Stop. They ignore the statutory scheme. Stop. They ignore binding decisions of the Supreme Court. Stop. They disregard the object and purpose of section 126. Stop. The authority treated a tenant as a consumer. Stop. It refused to recognize commercial use in an industrial connection. Stop. It ignored disclosure obligations. Stop. Such errors strike at the root of the order. Para. The petitioner seeks intervention of this court to prevent leakage of public revenue. Stop. It seeks restoration of statutory discipline. Stop. It seeks quashing of the impugned order so that the purpose of section 126 and 127 is not frustrated. Para. According to the petitioner, the impugned order cannot stand. Stop. The authority proceeded on a complete misunderstanding of the dispute. Stop. It treated the matter as a tariff difference. Stop. The inspection proves commercial activity in premises sanctioned for industrial use. Stop. Section 126 applies whenever electricity is used for a purpose other than authorized. Stop. The authority cannot reduce this statutory infraction into a Reclarification issue. Stop. It has rewritten the statute. Stop. This is impermissible. Para. According to the petitioner, the authority further erred in treating respondent number 2 as a consumer. Stop. The statutory definition is clear. Stop. A consumer is one in whose name the connection stands or who is supplied electricity for his own use with authorization. Stop. Neither condition is satisfied. Stop. The supply was in the name of respondent number 1. No authorization existed. Stop. Respondent number 2 was the unauthorized user. Stop. Yet the authority conferred consumer status upon him. Stop. Such a finding has no basis in a law. Stop.